Boying. Opo.
But when it comes to them going into the country, kung gusto nila pumasok dito upang manghuhuli at magpasagawa ng warrant na kanila pong na-issue po siguro ng ICC pagdating ng panahon, kailangan po itong dumaan sa ating court system. Ito po ay kinakailangan ng isang action to enforce a warrant, action to enforce a judgment. Kailangan po dumaan yan sa ating court system. Kaya hindi ho namin pakikialaman kasi yan po trabaho na ng Interpol kung talagang gusto nilang habulin yung tao na nasasaktal. Yung sabihin natin, nag-issue po na warrant of arrest ng ICC, gusto mong enforce ng Interpol dito, pero para ho ito ay matuloy at hindi ho magkaroon ng kasuhan, kinakailangan pumunta muna sila sa korte natin. There are some things that the Supreme Court would be looking at if what was alleged in the crime would have happened when we were still members of the ICC. That is one of the things that can be of importance to the courts when they do enforce a warrant, or if they will actually allow a warrant to be served in our country from an international tribunal. Ang problema nga ho ay meron kong sinasabi yung mga kaibigan natin na well-meaning naman. May 200 families daw na gustong magreklamo pero ang hawak daw nila 8. Pero sa 8, ang makakausap nyo 2 lang. Tapos yung 2 pa, wala pang ibibigay na totoong ebidensya. Napakahirap po talaga maghabol. Ang yung nag-hearing po ang Human Rights Committee ng Kongreso tungkol dito. At ang lumalabas po talaga, yung mga nangyari po kasing EJK nung panahon na yon, ay wala hong police report eh. Walang police blotter, wala hong record. Kaya napakahirap po maghabol talaga.
Ayun. Napakaliwanag at napakaganda ng paliwanag ni Secretary Boying na sa ICC man yan, Interpol man yan, dadaan yan sa korteng Pilipino.
Ma'am, ano yan eh? Ang general rule talaga, pag may foreign judgment, you have to enforce it in court. However, ito hong nangyaring ito, ang ginamit po namin dito, Section 17 ng Republic Act.
9851.
9851. Sabi ko kung basahin, ma'am. Can I read the provision into the record?
Put it on,
into the record. But may I read it into the record, ma'am? Thank you. In the interest of justice, in the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this act if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state pursuant to the applicable extradition laws and treaties. That is Section 17 of Republic Act 9851. So
Yes.
ito pa yung option na sinasabi ko kanina.
Yes, at yan yung pinag-uusapan natin kay Attorney Medina. Baka ibig ninyo mag-comment kasi mahaba po yung sinulat ninyo tungkol dyan. 9851, Section 17, at saka si Senator Cayetano. Unahin po natin na unang ma-recognize si Attorney Medina lang po. Lahat tayo, kabisado natin yung 9851, alam natin yung Section 17, para rin yung Rome Statute, Article 59, sa panahong to na memorize na nating lahat. Attorney po.
Thank you for the opportunity, Madam Chair. And with all due respect to our hardworking, brilliant Secretary of Justice, I beg to disagree purely on legal grounds. Again, constitutional, doctrine of constitutional supremacy. Whatever right that is granted by the Constitution cannot be diminished or be in derogation, cannot be diminished or lessened or stripped away by any statute. So if the Constitution guarantees that if a person is to be expelled from the Philippine territory by whatever means, a lawful order of the court is required. That grant that grant of the Constitution, that protection of the Constitution, cannot be lessened by any statute. So that in that case, 9851. So we have to interpret 9851 in accordance with the broad protection of the Constitution, which means that if you will surrender without judicial proceedings, that would be a violation. So there will be only a very narrow instance, there will be limited instances when surrender can be valid without judicial process. Yun lang po. Maraming salamat.
Senator Cayetano, I think you wish to add something.
When the SOJ was speaking, yung una kong temptation was to say that, as you said, no, evolution, legal theory, and for the public, no, to be fair, di ba? That happens when lawyers meet, di ba? Na ito yung una kong theory, ito yung application, especially if there's no jurisprudence na prevailing. And even if there's jurisprudence, you can challenge that, of course, but the law enforcers have to follow prevailing jurisprudence. So kanina, what I was tempted to do is to ask you that, you know, when tempers are down and emotions are way, let's see which theory is better. No, whether you need a foreign, when a foreign judgment or foreign arrest warrant from a foreign court or different countries here, whether we need court order or pwedeng surrender. Having said that, when I was thinking about it, what about, sir, this situation? So let's say that law authorizes the government to surrender a Philippine citizen. But if that Philippine citizen is asking for his day in court in a Philippine court. Kasi kung, again, hindi ko nakita yung buong video, but nakita ko yung part. I think this is more from the videos na pinost allegedly taken by Kitty Duterte, di ba? But I just saw portions. So isang portion doon, nung una sinabi kay Presidente, former President Duterte na sa Hague ka dadalhin, sabi niya, patayin niyo na lang ako or you'll have to kill me. I'm paraphrasing. No, but ang point ko, if a person says that, that means he's disputing it. So my point, assuming for the sake of argument, as the state, the Philippine government, can choose Article 17 to surrender, does that take away from the person being arrested the legal remedy of questioning the action of the executive before Philippine courts?
The option is always there if it can be done. But under the circumstances, it could not be done.
So no effort was made to get any warrant from a Filipino court?
I think
there
that
was
they
no-
were, the whole time that everything was happening until the evening, there were even attempts to show fake orders of the courts saying that there is a TRO on the action of the PNP.
Yes,
I believe
fake
that
news.
this was being showed by E.S. Medialdea. Am I correct, General Torre? E.S. Medialdea was showing them text messages that there was a TRO. So they were attempting, they were trying their judicial option. But
may
we
I-
already decided, it was already decided that
I think that's not
that Section
relevant,
17
Secretary.
of Republic Act 9851 will be the one used, the surrender part.
May I
Sige.
clarify that, ma'am? Just that part,
Yes,
no?
Senator Cayetano.
So we agree, di ba, na yun, ICC or whoever may, or extradition, or basta under that law, no? Dumating dito, inarrest, sabi nung Pilipinong inaresto, okay, no problem, I'll face court there, dalhin niyo ako doon. So, walang problema yung surrender, di ba? Kasi he or she surrendered to government, government surrendered under the definition ng surrender under that law, Section 17. But sabi mo, what was your exact word, sir? If possible or if... Ang sabi mo, nung tinanong ko SOJ na, can that person have the opportunity to question before a Philippine court?
If it's done, it can be done.
Yes.
Some people have been managed to get court orders in a matter
Yes.
of hours.
But
Only in this case, wala akong nangyari.
Yes, but yun nga ang point ko. Isn't the better rule, we give them reasonable time to do that? So that we don't deprive...
Ma'am, excuse me lang kasi there is a pending petition for habeas corpus in the Supreme Court.
Okay.
We might be stepping already on
Okay.
the,
So having
the
said
ground that, we have to
So we leave
take
it at
next week.
that. We have no desire to be
Yeah.
sub judice. Thank
Yeah.
you.
Madam
For
Chair,
the
can
reminder.
I
Yes.
just say this? Sir, I will respect that because nga mabigat di ba? Emotionally, legally. But can you study that part? Just for future cases, di ba?
Of course.
And when we say study, the defense lawyer will say 30 days, 6 months is reasonable. Of course, the law enforcement has to do its job. So in case we come up with a guidance,